why don't we go ahead and get started, and the other folks can jump on or join us as they can. My name is Lisa Furr, and I serve as a technical assistance advisor here for the National Center. I work with Lifespan of Greater Rochester, and we're very excited to have today's webinar being brought to us. We have Arlene Markarian, who's been a prosecutor for many years. She retired and 10 days later took over as the MDT coordinator for her county. She's currently the program coordinator for both the Safe Observant Seniors Elder Abuse Program and the Nassau County Elder Abuse Enhanced Multidisciplinary Team in Nassau, New York. In her previous role, as I said, she was an assistant district attorney with the Nassau County District Attorney's Office and was the creator and chief of their elder abuse unit. Prior to that, she worked as an assistant DA with Kings County Brooklyn District Attorney's Office for over 26 years. She's been doing this work for a good long time and has a lot to share with us. What we're going to do is we're going to let Arlene go through the slides and discuss things, and then we'll take questions at the end, and I'll make sure to give a time marker so that we know where we are with time, so we'll be able to do that. All right. So I'm sharing the screen. Are y'all good with that?
It's not in slideshow mode though, is it? Or is it?
All right, hang on.
It is.
Did it stop? All right, let's see. Here we go. Is that better?
Perfect.
Okay. The trick is to put up the program, not the screen. Okay. So we're going to talk today about the hang on, I'm having trouble with the advancing. Okay, so this is being presented by the Office of Victims of Crime, funded through the Department of Justice. These opinions, findings don't represent the DOJ, but are the information from the presenter. Please mute yourself if you're not speaking. If your name isn't on it, I think we're all good on that. Please use the chat feature for questions, and if you can, go ahead and add in the information as to where you're from in the chat so we can get a sense of who's here. All right. And Arlene, I'll let you give your legal disclaimer.
I'll do that. Well, it's right there, but basically the bottom line is this, is that whatever you see in this presentation or hear in this presentation is not legal advice. Of course, legal advice depends on every situation. Any of the materials, the handouts, anything is not meant to give you legal advice. And if you need legal advice, please contact either your agency's legal department or an attorney of your own choosing.
Thank you. So what we're going to be doing today is to familiarize yourself with the elder justice, familiarize the elder justice professionals with the types of courtroom proceedings, tips to increase competency and comfort in testifying in court, and increase comfort in working with courtroom professionals. All right, Arlene.
Okay, I will. Hi, everybody. I'm really happy to be here. This I really should call also Testimony 101. These are just some basic things that over the years of being an active trial attorney in elder abuse and domestic violence that I've learned over time after each trial and working with my colleagues in the DA's offices. So this is, let's just start off with courts and types of proceedings. You have criminal court. And in criminal court, there'll be grand jury, which is, I can speak for New York State, grand jury is what's needed if you're going to prosecute felonies in New York State. You need an indictment, and that's gotten through the grand jury. You have pretrial hearings, which are, just as the name sounds, they're hearings before a judge in court before the trial. Those hearings could be anything from what's called evidentiary or suppression hearings. For example, if a defendant makes a statement, the defendant's entitled to a hearing where the law enforcement officer that took the statement testifies to make sure that it was obtained within the offender's constitutional rights. If it's not, the statement could be suppressed. So there are many types of pretrial hearings. And then finally, there's trial. A trial, and I could speak again for New York State, is going to be jury or bench. Jury is a jury of 12 people in criminal cases. Bench trial means that it's just before the judge, and that would be the defendant's choice, whether the defendant wants to go before a jury or if he or she wants to do the trial and just have the judge be the person that renders the verdict. Civil court, you have family court, of course, whether it's, especially in ElderAbuse cases, probably the most common is going to be family court orders of protection. You have guardianship, or in some states it's called a conservatorship, where the judge is going to hear testimony to determine whether an adult needs to have a guardian appointed. And there are other civil proceedings where there'll be testimony, perhaps, especially in ElderAbuse, we see here in Nassau County, we've been seeing a lot of foreclosure proceedings and eviction proceedings. So these are civil court, not criminal. And these are the types of testimony. So my friend and colleague, Tracy Siebert, we presented this for the New York State EMDT conference, and she contributed to this PowerPoint, and she came, I don't know if anybody has ever seen My Cousin Vinny. If this was live, I'd ask you all to raise your hands, but I highly recommend that if you haven't seen the movie, to watch the movie, because Joe Pesci does a lovely cross-examination on a number of witnesses, and I used to tell my assistant DAs this all the time. So this is just a scene from the movie. You have types of testimony. These are your general types of testimony. There's direct examination. We're going to talk about these in a minute. There's cross-examination. There's redirect examination, recross-examination, and so on and so on. And I'm going through all this because you're going to get this PowerPoint, the slides, you're going to get them as a handout, so you don't have to worry about writing any of this down. But it's important to know, if you're going to be a witness in the case, to make you more comfortable and understand what your role is, to know how the trial works and what the purposes are of these different types of examinations. So direct examination, that means that the questioning is done by the party calling the witness. So if it's a criminal case, the prosecutor calls you as a witness, and they put you on the stand, and they start off first by asking questions. And as it states here, the purpose is to elicit the facts. What do I need from you as the witness? Are you an eyewitness? Are you a professional witness describing your investigation? Am I trying to enter evidence regarding the case through you? So those are some of the purposes of the testimony, and if you're testifying as a professional, we'll go over your qualifications, your background, or perhaps as an expert witness. And they're generally open-ended questions. So what I mean by that is, if you're called to the witness stand, for those of you that have never testified, you're going to be, if you're called, and the prosecutor or the attorney that's calling you as a witness is going to ask you everything from, what do you do for a living? Tell us some of your duties. And you see how, and they'll ask you, are you familiar with this case? Can you tell us what happened on this date? They're relatively open-ended questions, and then you answer the questions. A lot different than cross-examination. So in cross-examination, the opposing party now gets to ask you questions. Once I'm done asking you questions, so make me the attorney that's calling you, now the defense attorney gets to ask you questions. And that would take a different form. Generally, the questions are what are called leading questions, which means you would probably have to answer the question yes or no. It only requires a yes or no answer. So they get to put the facts. They get to say something along the lines of, isn't it true, something, something, or whatever the facts are. And then your answer is supposed to be either yes or no. Sometimes you can't answer it yes or no, and you would let the judge know, I can't answer that in a yes or no. The general purpose of cross-examination, there are many purposes. The main ones are these: to discredit the opponent's witness or their testimony by showing either your prior bad acts, what is, depending on what kind of witness you are, your inability to perhaps be reliable. Like, for example, if you were an eyewitness, but you were drunk at the time, or perhaps you've got a bad record with your employment and you're being called as an employee of that place. Your bias or hostility regarding the case, mistakes that you may or may not have made, and any, of course, lies or misrepresentations. Any of those things or what the opposing attorney is going to want to probe you about, ask you about, to show that you're not reliable, you're not being truthful, or not being truthful in your testimony. Of course, on the flip side, if there's something you're saying or that that could be helpful to their side, then they're going to ask you that as well. So anything that they think that you're going to say that's helpful to them, they're going to want to ask you those questions as well. And we just talked about there's leading questions as opposed to open-ended direct questions. They're not open-ended generally. The attorney is trying to ask you a question where all you can answer is yes or no. And the reason for that is that they want to control you and what you're saying. Now, after you've been done with cross, I am then permitted to clarify some things that may have happened during cross-examination. So it doesn't mean I can go back over the entire case. It just means that if you were asked certain questions by opposing counsel, now I'm the one that called you to the stand, and I think that there was something that's misleading, or I want you to clarify something, I'm going to then be permitted, assuming the judge lets me, I'll ask if I can redirect, and I'll ask you some very limited questions. And then it is possible that the other side may want to cross you again. I don't want to scare you. I mean, typically there is a redirect and there may be a recross. It really doesn't usually go much further than that. It can, but the judge keeps usually a very tight rein on it, and it's less and less questions, because that's the whole point of it, is everything should have been brought out on the first 2 rounds, basically. Prepping for testimony. This is one of the most important things to make a witness comfortable, to make the attorney comfortable, and to let the testimony go as smoothly as possible. And we really cannot underestimate the trial prep. And trial prep, as I would tell my assistant DAs, does not happen just the night before the testimony or the morning thereof. So here we go. It really, trial prep just starts off for you as coordinators, as potential witnesses, from the beginning of the case, if you're working, you're a coordinator, but you also work for an agency, your investigation, and your paperwork, it all starts there. So, so that's why it's so important to be as careful as you can in your paperwork and your investigation and documents. There's a question of, many times I'm asked, well, what are they entitled to? Can they get my paperwork? It's confidential. And while your paperwork may be confidential, it's not going to be protected if a judge believes that it's necessary, especially for a criminal case where somebody's liberty is at stake. There will be arguments in court as to whether or not the defense is entitled to what would otherwise be confidential records. Sometimes they are entitled to it. Sometimes the judge will take it and look at it, what they call in camera, without anybody else looking at it, to see if there's anything under the law the defense would be entitled to. For example, if your notes indicate that the victim told you that the defendant didn't actually commit the crime. That's a big thing, and the defense would be entitled to that. So this is just very one of many examples, but your paperwork can very well be, and if you're being called as a witness, will be subpoenaed most likely. Just one more back. The trial
Sorry.
prep. No, it's okay. Let's see. And the trial preparation, by the way, by the attorney for the witness is going to be first, is about direct examination. They should be prepping you for what cross-examination as well as possible opponent tactics. So you have your initial debrief. This is for me. Every attorney is going to be doing just things their own way. And also the issue is going to be how much time do they have? Because I'm not going to lie to you, depending on the jurisdiction and how busy it is. Sometimes trials are going very fast and cases are getting old, and somebody may inherit a case that only has a couple of days to get ready for it. And it can be very stressful. So, but under the best case scenario, what I would do is I'm going to bring in my witness for an initial debrief. What do I mean by that? I'm going to bring you in and just talk. I want to go over everything with you. I want to get your impressions. You're a professional witness. You worked on the case. Tell me, what happened. I'll be reviewing your paperwork. Then I would probably bring you back, or maybe in the same session, go over your direct examination questions. I want you to know what questions I'm going to be asking you in what order. It's absolutely fine. There's nothing wrong with that. It would be, in fact, ridiculous to put somebody on the stand without any prep, because then you'd be all over the place. So I would go through the questions with you. And then at some point, I'm going to go over also what I think you're going to get cross-examined with. A trial attorney needs to figure out what the defense is. And we need to figure out what kind of questions that we believe the defense is going to ask you. So this way you are prepared for those questions and you can answer them. And then finally, we're going to go over a courtroom, things that go on in a courtroom, things that may come up. An example is refreshing your recollection, which is something you're allowed to do. If you can't remember something, you could ask to refresh your recollection, where you can review your notes and then testify about it to remind yourself about an address, about a phone number, about a date, whatever it might be. So we just talked about pre-trial or pre-testimony conference to discuss the case and your testimony. We also want to talk about what was your role in this case. There were different types of witnesses. I'm assuming most of all the people that are on here are probably going to be testifying as a professional. The fact that you were involved in investigating the case or assisting the victim post-crime, as opposed to perhaps an eyewitness to the incident. Or a police officer. If you're a police officer, certainly it's going to be involving what you saw and observed at the scene of the crime, etc. I'm going to talk to you. We need to talk about the strengths and weaknesses in the case. So when we talk about strengths and weaknesses, I'm going to tell you what I think they are, but I also want to hear from you as the professional, because you're the one that was working on the case. But we want to address the strengths and weaknesses because every case has got weaknesses. And if you're not ready for them, that can be the Achilles heel during the trial. We want to review all documents and notes you created and any minutes of prior testimony. When court reporters take down what you're saying, those are called minutes. And we want to review any evidence, any photos, recordings, or other evidence relating to the case with you. We want to review the questions again on direct, as well as preparing you for moving items into evidence. What does that mean? You're testifying at trial, and maybe you met with the victim and you observed injuries. I may want to move a photograph of injuries in through you, or have you look at photographs of injuries to say this is what that victim looked like on the date that you met with them. Maybe I'm trying to move in some of your documents into evidence. And there are ways of doing that. The law requires the attorneys, when moving things into evidence, to ask certain questions that's called laying the foundation. asking certain questions that would allow the evidence to come in, for the judge to approve it. A defense tactic is to, we want to review defense tactics, which is preparing for anticipated questions by opposing party, as well as things like certain kinds of objections. One thing that I would tell my witnesses about is that many times the opposing party may object just for the sake of objecting if you've been talking too long and they want to ruin your flow. And so I warn them about it. Just because you're hearing an objection doesn't mean you did anything wrong. There may be legal reasons why, there may be no good reason why. And really, it's as soon as you hear an objection, you should stop talking to allow the parties to be heard and the judge to rule on it. But the attorney that preps you, and I should say this, whatever I'm telling you here is based on my experience, but you want to listen to the attorney that's actually prepping you for your case. Whatever that attorney is asking you or telling you is what you should be going by. So courtroom demeanor is another important thing to talk about. Professional appearance is very important. If you're going into a courtroom and you're testifying, you want to look like you respect the court and the jurors. You don't want to go in there in regular street clothes. You want to go in there as if you're going on an interview, a business interview. I tell people, depending on, I'll pick everything from if you're going to your house of worship, if you're going on a business interview, depending on how you dress for work, but you want to look professional. You also want to make sure that this affects your demeanor because your self-confidence is part of your demeanor. And you want to follow your agency guidelines in the work that you do. That's all protocols. And that includes if you get a subpoena for documents, that you don't just hand over documents without talking to your supervisor, without talking to legal. This is a legal proceeding. You want to check with an attorney before you start turning over things. So you want to make sure you follow your agency guidelines. I mean, as soon as you find out that you're being called as a witness, you're going to want to let your supervisor know and probably your legal department know. Familiarization, I'm having a tough time with that word today, sorry, with courtroom layout. I have taken many witnesses to a courtroom to take a look around the room, because especially if it's your first time testifying and you've never been in a courtroom, it can be very overwhelming and it can be very intimidating. And so you want to, if it's the first time you're testifying, you want to make sure that your attorney that's prepping you knows that, and you can ask to see the courtroom. And we can take a look over the courthouse, even if it's not the exact courtroom, the one next door to it. We can go in and look around, and you can see where the witness box is and where you have to walk and how to walk around and where to stand. It will make you feel much more comfortable. So more, again, types of testimony. There's going to be factual, which will come from your memory or from your documents. Expert opinion. Professional explaining their investigation. I already touched on some of these already. You have eyewitnesses, which is self-explanatory. We have ear witnesses, people who have heard things, okay? Walls are thin, especially in a lot of apartment buildings, and people overhear things. Nose witnesses, I call them. I mean, if you can imagine, think about what a nose witness is. I had a case once where a police officer got called to the location via 911 for a foul odor coming from an apartment, and he thought he was going to, quite frankly, what would have been a dead body. Maybe somebody passed away in the apartment, but he told me that as soon as the elevator doors opened, it wasn't dead body odor that he smelled, it was body odor and feces and urine that he smelled. And fast forwarding, when he went into the apartment, he found a severely neglected elderly woman who was in her feces, her urine, and that smell, and that had been going on for a while, and it emanated into the hallway of the building. So a nose witness in that case is very important, just like a nose witness in an arson case. If they smelled an accelerant or smoke, that could be very important when that happened. And again, evidence being entered through a witness. These are just some tips for the witness stand. So let's go with the please do not. Do not ever guess. Okay, guessing is bad. Either you know the answer or you don't know the answer. But guessing is rarely ever going to help anybody and is actually improper, I think, probably in all circumstances. So don't guess. Answer questions. Do not answer questions that you do not understand or didn't fully hear. And what I mean by didn't fully hear is this. I've testified multiple times at trial. And what happens when you're on the witness stand, especially if your heart starts pounding and you're nervous, is that you may not hear the entire question. And then you hear the back end of the question and you answer, but you didn't hear the front end of the question. And now you're stuck with that answer. So if you did not hear the full question, there is absolutely no reason why you can't say, I'm sorry, could you please repeat the question? I didn't hear it. Or I'm sorry, could you please repeat the question? Or I don't understand the question. You can say that in response to the question. In fact, you should. You don't want to answer a question that you don't understand or didn't fully hear. During cross-examination, do not look to the attorney or the prosecutor that called you for answers while on the witness stand. I've had this happen to me during trial. The jury is sitting there, they can see you doing it, the defense attorney can see you doing it. You're on the stand and the attorney is here, but now you're talking to them and then you take a pause and now you're looking at me. And I'm now going like this, looking over my head or looking down at my papers because I don't want to look like that I'm somehow coaching you. So I can't help you at that point. So just do not, try not to look at your attorney that's there, ask that called you to the stand because you don't know the answer to something or you're uncomfortable with the answer. This happens a lot on the witness stand, especially I've had it happen with law enforcement. The opposing attorney, I'm going to call it the defense attorney, is coming at you and they're just peppering you with questions. And maybe you think they're being snotty, maybe you think they're being disrespectful. And my job as an attorney is to really object and tell the judge, and say to the judge, this is inappropriate, this and that. But it depends. Sometimes it is appropriate and there's nothing I can do about it. Your job cannot be that because you're sick of the lawyer and you don't want to answer any more of these questions, cannot revert to, I don't recall, I don't recall, I don't recall under cross-examination. Because on direct examination, you're answering all my questions. Now the defense attorney is asking you questions and you're saying, I don't recall, which by the way, is clearly not true because you answered and you talked about it during direct examination. So not only but you're doing it out of frustration, but it's actually not even true. So, and everybody knows it. So please don't revert to, I don't recall, I don't recall, I don't recall, because you're now really pissed off at the attorney. You don't want to deal with this anymore. And believe me, I understand. I've been there. So, but it doesn't play well at all. And it's just not good for you as a witness on the stand. Some do's. Please, again, say, I don't know, I don't remember, if that's the truth. I'm sorry, I don't know, I don't remember. Say when you disagree with a question's premise. What do I mean by that? And I hope I'm not going too far in the weeds, but I've seen it happen a lot where the opposing attorney, the defense attorney may say something like, after you, I'm going to use a police officer as an example. After you handcuffed my client and asked him his rights, is that when he gave you the statement? And that's when he gave you the statement. Well, you did read him his rights, and then he did give you a statement, but you didn't handcuff him first. Or you had handcuffed him, but then you uncuffed him. So you're disagreeing with a portion of the question. Okay, so if you don't agree with the premise or you disagree with something that's in the question, then you need to clarify that for the court and for the jury. It's okay to say, that's not what I said. No, he was not cuffed when I asked him the questions. So you just need to hear again, listen to the entire question. If you say you don't, do say if you don't understand, and do ask for a question to be repeated, and do say you're sure when you are sure. This is probably the toughest part. People get very nervous on the witness stand to say they're sure about their answer, especially when the cross-examination goes, is being repeated, and it's like, is your testimony blah blah blah, and you said this blah blah blah, and are you sure? Are you absolutely 100% sure that it was, whatever it is? And if you are sure, then you should say you're sure. Okay? The purpose of that cross-examination is to make you become unsure. So the question is, knowing before you take the stand how sure you are about your testimony and what you're saying. And that's part of prep. Listen carefully to the entire question. We talked about this. Have the question repeated. Let's see. During cross-examination. Oh, this is one that's important. During cross-examination, take a breath before answering for a couple of reasons. First of all, you want to make sure you heard the whole question. So the person asks you a question and you take a breath and then you answer. I'm not saying, take a 5-hour breath, just a short little pause, little breath. So this way, if there is an objection, if I want to object, if I think it's an inappropriate question, I'm going to object. I'm going to say, objection, Your Honor. But I'd like to object before you answer, because the whole point of the objection is the jury, I'm saying the jury that you shouldn't be allowed to answer that question for whatever reason I have as an attorney. Okay, so, but once the cat's out of the bag, so to speak, the cat's out of the bag. We like to keep that kitty in the bag. Okay, so just take literally just a little breath, so that if there's an objection, it's coming out. And then I always ask my witnesses to listen to the objection. One of the things I would object to is objection. That's not what the witness testified to. If you hear an objection like that, that's kind of like letting you know that the attorney doesn't like what the other attorney asked you and that they're mischaracterizing your testimony. There's something wrong with that question. And, and I can make a mistake when that happens. So all you really need to do is just say, can you please, ask the question again, and listen to the question and for that purpose. But that is, listen to what the objection is, because that can lead you to where, what the issue is. Another big one is this. Don't volunteer information on cross-examination. Just answer the question that the opposing counsel is asking you. It's very important. We all want to explain our answers. We don't like the way the question's being asked, and we feel like, maybe the jury's not understanding. Well, that may be true, but that's what redirect examination is for. Then I get to ask you questions to fluff that stuff out. But do not volunteer information. Also, because there may be a reason why I am not fluffing it out. I'm not going to go into all the reasons why, but there may be a legal reason why I think I like the answer just the way it is, and I don't want to fluff it out. So just answer the question, nothing more, nothing less. And be cautious whenever you're asked for an opinion. Honestly, the only time you should be asked for an opinion is if you're called I can only speak for New York State because different states' rules of evidence are different, but in New York, in order to give your opinion on something, you would have to be called really as an expert witness. I mean, there might be some exceptions to that, but otherwise, in a criminal case, generally, you would not be asked, you probably wouldn't be asked your opinion on most topics. Speak clearly and slowly. I tend to speak fast, as you may have already noticed, and I'm not necessarily in a rush right now, but I might be what many people might call a typical New Yorker. I do speak fast. And so you don't want to speak like I am, but you do, you want to take it slow, but you want to make it clear. Speak as clearly as possible. If there's a microphone, use the microphone. If you think you need a microphone, you should let the prosecutor know. Just to make sure there is a microphone in the courtroom. Remember, there's a court reporter taking down everything you say. Shaking your head yes or no, they don't take that down. You have to use words. And you want to avoid police or other agency jargon, abbreviations. One of the things I used to always prep my officers on is when I'm talking to my officer in the office, and I would say, well, after you got the 911 call and you responded to the location, what did you do? And they said, I exited my vehicle. I'm like, well, that's nice. But when you go home and tell your husband, your wife, your kids, or whatever your friends, what you did that day, do you say to them, you exited your vehicle? Or what do you say? Well, I got out of my car. I got out of the police car. I'm like, okay. Well, then, I prefer you say it that way, but whatever comes out of your mouth comes out. But try to avoid jargon. You're talking to regular people. So you want them to understand, you don't want abbreviations and things that they don't understand, because then I'm going to have to ask you, what do you mean by that? What do you mean by that? And this goes to speak in your own words. So look, you're going to learn this during the prep with the attorney. Now, the attorney may want you to use certain words, okay, or suggest certain words. And if you're comfortable with it, great. But if you're not comfortable with it, let the attorney know, because a jury, just like you, can always spot a fake, and you don't want to be fake up there. Fake does not go to good credibility. You want to be real with them. So speak in your own words, and you're going to go over it, obviously, in the prep with the attorney. Don't exaggerate. This isn't storytelling, and who's going to, don't exaggerate. Just be as accurate as you can be. And unfortunately, we all make mistakes. And sometimes we're in the hot seat for those mistakes. But the attorney should be prepping you about those mistakes and how to answer the questions, and how to not be combative with the opposing attorney about the mistakes. So admit whatever you did wrong, but on the flip side, if you didn't do anything wrong, don't just throw yourself on the sword and start admitting things. If you did something wrong, if you made a mistake, you admit the mistake. The attorney putting you on the stand will probably ask you to explain to the jury how that happened. So it is what it is. And always be aware of your body language, because there's a difference between sitting up straight and answering the questions versus one of these things, going like this, looking at your nails. And I kid you not, because it's amazing what people will do on the witness stand. So please be aware of your body language. Even more testimony tips. Again, these are just some tips over my career that I prep my witnesses with, and so I'm hoping these will help you, and any attorneys, to help them prep, and also just so you know. This probably goes without saying, or maybe not. I don't know. Sometimes people think, you're on the stand and you're mad, and the jury should know it. Well, not so much. You're the professional. You need to try to control your temper and remain courteous. I've had professionals on the witness stand lose their temper. I've also had regular folks that aren't the professionals in the case lose their temper. And they're two different types of testimony. As the professional, you want to keep it together. You want to remain courteous. You don't want to argue with the attorney or the judge. That's what the attorneys do. Let us attorneys do that. Let the jurors be annoyed with the attorneys and not you. Okay? So just take that breath if they're getting under your skin, and answer the questions, and remember who you are. You're the professional in that courtroom. Refreshing your recollection, we touched on earlier. If you don't remember something, you'll go over this in prep. So the attorney may even ask you on the stand, you need to refresh your recollection. Or you may ask, can I refresh my recollection? The answer may be by the judge, or the attorney may say to you, what do you need to refresh your recollection? My notes, my notes from that day. Do you have them with you? Yes, I do. Here's the thing, in New York State, I can only talk about New York State. You cannot read from your notes unless they were moved into evidence. So if all you're doing is refreshing your recollection and the notes are not moved into evidence, you may pick up your notes, you may look at them, you may read them to yourself, not out loud. And then when you're done, you look up. And then somebody's going to ask you, are you done looking at your notes? Yes, I am. Is your recollection or memory refreshed? Yes, it is. Okay, what address did you respond to that day? Or whatever the question is, and then they'll ask you again, and you'll answer the question. And that can be done multiple times. It's okay. And depending on the notes, sometimes the attorney may try to move them into evidence so you can just read from them. But it depends. And it's up to the attorney what they want to do, and then they can ask, and then they still may not get what they want anyway. Do not discuss the case or your testimony with other witnesses, the media, victim, family, anybody, until the case is over. Okay? In fact, you should discuss your testimony once the case is scheduled for trial. Talk to the trial attorney about who you're allowed to talk, who you should talk to, if anybody, about this other than the attorney, because you can get cross-examined on it, and that can be an ouchie. But not only that, sometimes you think your testimony is over. You finished, you're off the stand, you think you're done. but then something comes up later in the trial, and now you need to be recalled to the witness stand, okay? And now you're going to be asked by the opposing party, did you talk about your case? Did you talk about your testimony with anybody, the DA, the police, the this, the that? It's a lot cleaner and a lot easier if you just tick a lock and wait till the whole case is over, and then whatever agency protocols are, whatever it is, follow those regarding who you should talk to or can talk to, okay? And the best practice, like I said, until the case is over. Recipe for successful testimony. Well, this is keeping a very basic recipe. Of course, if it's your own knowledge, it's your facts, you worked on the case, having your personal knowledge of it's going to make it easier for you. Sometimes professionals have to testify about somebody else's case. That person's out on family leave, or they've left the agency, or they're, God forbid, passed away, or whatever the reason is, that person's not available for the trial. But you, depending on the kind of case, you may be able to testify regarding that investigation as that person's supervisor or as that person's, colleague, depending on the kind of case it is. That makes it a little bit more difficult because it's not your case. So you really need to review that case left and right, upside down, so that you feel very comfortable with the facts of the case. Trust me when I tell you, the more comfortable you are with the case, the more comfortable you're going to be on the witness stand. The nerves come from when you start realizing that you really didn't look over all the paperwork carefully, and you really didn't read everything carefully. And now you're being asked questions and your heart starts to race because you're not sure about the answers. And it's a lot better when you really do your homework. So you want to make sure that whatever you write your files is accurate. And you'll go over your agency protocols and that, but you don't want to make guesses. You don't want to put, if your opinion is not needed or not required or not supposed to be in there, then don't. I mean, so think about what is important and what you're supposed to be documenting. You want to, when you're reviewing your case file before testimony, you want to look at your case file for inconsistencies and mistakes. You want to, you're doing it because you want to make sure the attorney calling you knows about it, okay? Because they may miss it, because the defense attorney may not miss it. And the last thing we want is for the attorney to be surprised about something during cross-examination. None of us like that. We hope we catch everything. Sometimes we don't. But if you catch something, that's the stuff that you want to talk to the attorney that's calling you about. You want to make sure they know that you caught a mistake or an inconsistency, and you can discuss it with them and how to handle it. And make sure that you ask the attorney about being prepped as soon as you hear that the case is going to trial. You want to find out about prep. When can they prep you? Make sure you make time for the prep. Supervisors, make sure your caseworkers are prepped and that they have time to be prepped, because I've seen supervisors who have said, no, it has to be on your own time. No, we don't have time for this. And it's very short-sighted, and it's really putting your caseworker, your people, into a bad way by not allowing them to get the prep that they need. And on the flip side, attorneys never want to over prep a witness, because, I'm going to bring you in a couple times. And once I've gone through everything with you earlier on, I may bring you in one more time closer to the date, just to refresh everybody's memories. And that's it, because I don't want you up there, sounding like you rehearsed, because you're not rehearsing. And so we don't want you to sound like you are. And so be prepared. Sample cross-examinations that come up in many trials.
So we're about at 10 minutes, Arlene.
And what screen? How many more screens? I'll figure it out. Don't worry.
Okay.
How many do I have? Do you know? Oh, no.
I don't.
All right, we'll figure it out. I think I'm pretty close to done. So, okay, just quickly, I learned this early on when I was a brand new assistant DA. I didn't know my first trial. I didn't know. And then I see this happening on cross, and this is where my title of this presentation is Deer in Headlights, because here's how the questioning went. Officer Jones or Mr. Jones, you met with the assistant DA about this case, haven't you? Yes. And you met with the ADA numerous times regarding your testimony in this case, didn't you? A few times. And you went over and the assistant DA told you all the questions that she was going to ask you, didn't she? Yeah. And The assistant TA even told you the questions that she thought I was going to ask, right? And now all of a sudden somebody's getting nervous, like something bad happened and that shouldn't have happened and the TA did something wrong. And now we're getting into deer in headlights because I didn't warn you about those questions. And the attorney is using this tone like you did something naughty. It's a trial tactic. They're allowed to do it to a degree. And the truth is that if you're not prepped on it, you can see how you may get nervous and start wondering, hey, what's going on here? The simple answer is just answer the question. There's absolutely nothing wrong with prepping. And in fact, it's malpractice in my eyes not to prep a witness in some way, okay? And the judge knows that, and in fact, we can clarify it if we have to, but just answer the question, no matter how naughty they're trying to make you feel. Just be like, yes, I did. And you met with her numerous times, about 2 or 3 times. And she told you what questions yes, she did. And she told you what questions I'm going, well, the ones she thought you might. You see how I'm doing that. It's okay. You didn't do anything wrong. Another question is, well, you weren't there, so you didn't see what happened, right? Okay. No, no, I didn't see what happened. That's okay, because that's not why you were called. Mistakes we talked about, memory. Oh, this is another one. This case is over 2 years old. So you don't have any independent recollection of this case, do you? You expect the jury to believe that you remember this case? Yeah, I do. Guess what my redirect is going to be? Because I'm going to prep you for this. My redirect is going to be, why do you remember this case? I remember this case because the victim in the case had, reminded me of my mother, or had the same name as my mother, or because she was so injured, I never saw anybody that injured before. Whatever the answer is, they're not going to like it, but they shouldn't have asked the question. Okay? I'm actually very happy when they ask a question like that, and I know I prepped you for it. Okay? Because then I know I can then ask you that redirect to explain all that. Let's see. Oh, that covers it all. Additional tips, and this is from Tracy from a social worker point of view, which we always need in this. And so I thought this was, nice to leave on here, and important. She said also, answer only what is asked of you. She's the one that also says, take a breath before answering. Prep is important, but her main thing is, and I agree, be kind to yourself. This is challenging work. So whatever happens, happens. As long as you're being truthful and you're being as accurate as you can, the rest will fall into place. Okay. Always remember to ask to review your notes. Professional use of self. I had to ask Tracy because this was her screen. I asked her, what does she mean by this? I'm going to read you her answer because I couldn't remember what she meant. And she said, all social workers will understand professional use of self. Being your authentic self, but a professional version of it. Don't be an autotron. Be yourself. So yes, I agree. This goes to be, yes, be yourself, be professional and be true to yourself. And again, as always, with any testimony, it's always going to be the most important thing is to just be honest and just be honest. And this is why we're going over all this. I'm hoping now you see just a tidbit, a snippet as to why it's so important to know this stuff and be prepped about it. Because deer in the headlights, I am not kidding. This is when I'm sitting there as the attorney and I realize that my witness, I may have even prepped them on it, by the way. And now they're just nervous and they're staring off and they're getting this look in their eye. And I'm like, the bubble over my head is going to be, oh crap. This may not be good, okay? And it's very hard on you, more harder on you than me, because you're on the stand. But it's not, so the whole goal of this is that you're comfortable, you're ready for the questions, and I am happy to tell you in the vast majority of cases, as I became a much more seasoned trial attorney, I've had many witnesses tell me, law enforcement and otherwise, that my cross-examination prep, I was a lot harder on them than the defense attorney was, and it felt like a piece of cake. And I was quite happy with that because I knew I did my job. And that's what I'm hoping will happen to you. I want to be harder on you in prep so that when you get into that courtroom, you're not deer in headlights. And I really do appreciate all the work that you do. I love the fact that this is national and throughout the country. And I'm a big believer in the EMDTs. I've been doing it for a long time. So thank you for the work. I know it's really hard and can be incredibly stressful.